impression that the panel would have been provided with a copy of it by one of the relevant departments, so we didn't provide a copy. We do have a soft copy of it though, and we will email it to the Commission to allow you to have access to the policy and the accompanying guidelines. What has become apparent to us over the past 2 days is that firstly, in line with what I've just said, there is an adequate knowledge of and compliance with the provincial learner transport policy in the Northwest. This has become particularly apparent after listening to the testimony yesterday from COSATMA. This is highly problematic. If the departments are not guided by any clear policy, firstly a policy that already does exist in their provisioning of scholar transport, then the reason for much of the confusion regarding the roles and responsibilities of both COSATMA and the Northwest Department of Education becomes quite apparent. But the second thing is it also creates a great deal of variation in the provisioning of scholar transport in the province. And we do recognize that a degree of agility is always going to be necessary when it comes to responding to crises in scholar transport provisioning. But if there is no clear guidance in a policy, then a failure by any state department to comply with the policies that are laid out in those documents will always endanger the reliability of the service delivery that that department is responsible for. And it does make it considerably harder to hold that department to account. So ultimately, it's fundamentally important to understand that a very good and clear policy document is going to be necessary to guide both COSATMA and the Departments of Education when it comes to provisioning and the provisioning of scholar transport in the Northwest. So what I'm going to do in the submission today is just briefly contextualize the right to scholar transport and the continuing scholar transport crisis that we see in the Northwest. Thereafter, we're going to discuss several inadequacies in the policy that we found as a result of our close reading of the policy and its accompanying guidelines, and make further recommendations regarding what both COSATMA and the Department of Education could do in order to address these individual irregularities in their policy, but then also make further recommendations on what we think is an overarching solution to what is in fact actually a national crisis when it comes to the provisioning of scholar transport, which is advocating for and lobbying for the adoption of binding norms and standards for scholar transport. We think that the reason why so many provinces are struggling to meet the need for scholar transport is fundamentally because they aren't being given adequate guidance when it comes to developing their transport policies, which is a recipe for disaster and sets many of these policies up for failure in implementation. So the nature of the right to scholar transport is canvassed more fully in our written submissions, but I do just want to highlight some key features of the right that I think are necessary for the discussion we'd like to have today. Firstly, learners' physical access to schools has been recognized as a necessary condition for the achievement of the right to basic education, of which scholar transport is a recognized and acceptable integral component thereof. The right to education would be meaningless without transport to and from schools at the state's expense in appropriate circumstances. Because the right to scholar transport is a corollary of the right to basic education, it is also not subject to any internal limitations or qualifications, and as this commission has already established through its questioning, it is immediately realizable. What this means is that government departments need to take all necessary steps to ensure that it both plans and budgets in such a way that it can meet the demand for scholar transport in the fulfillment of its constitutional obligations. Where the state is aware, like the departments in the Northwest currently are, of the fact that there are significant issues that may hinder the realization of the right to scholar transport, they are required to take proactive steps to remedy these issues. Our courts have been incredibly clear and crystallized the fact that you cannot react retrospectively to a failure to comply with the constitutional obligations stemming from the right to basic education. It is incumbent on all responsible departments to act proactively. What we've realized as the Legal Resources Centre in our involvement in both litigation and advocacy on the right to scholar transport is that it is fundamentally important to ensure that there is an adequate framework to guide the provision of scholar transport within various provinces, but also that there has to be effective implementation of those particular frameworks in order to ensure that learners have access to a safe, reliable, and integrated transport service that caters for the needs of learners, as provided for in the National Learner Transport Policy. A key contributing factor to this is making sure that clear guidance is given to all officials responsible for scholar transport provisioning, that makes it very clear where the start of their obligation is and where it ends, and also makes it very clear when their actions are required within the process of scholar transport provisioning. We readily concede that it is a complicated process. You have to align an assessment of what there is the need for within a particular province when it comes to actual scholar transport, align that with budgetary provisioning, and then also align that with procuring the necessary service providers. However, what's also incredibly clear is even if this is a daunting and difficult task, it is not one that any department can shy away from merely because it is difficult to achieve. It's become apparent in the crisis faced by many provinces, such as the Northwest, that ensuring the provision of scholar transport is a multifaceted problem. There is a significant cause of this crisis is the failure to ensure that there is an adequate regulatory framework in place to guide provincial education departments and provincial transport departments, which manifests in inevitable implementation issues. What I'd like to do now is just turn to the Northwest's provincial learner transport policy and its guidelines, and just provide a brief overview of some of the inadequacies that we've recognized are present there that we think feed into the poor implementation of the policies in question. So in recent years, there's been a marked increase in the number of learners identified as in need of scholar transport in the province, and a decrease in those for whom scholar transport has been provided, according to statistics provided by both COSATMA and the Departments of Education in their annual reports. But what was also highlighted yesterday, and most concerningly so, is that there's been a stagnation in the budgetary allocation towards scholar transport in this province, despite the fact that need is increasing and despite the fact that provisioning has been simultaneously decreasing. Contrary to the testimony, as I've already said earlier, there is in fact a provincial policy that is intended to guide the provision of scholar transport in this policy. And it's very clear that all provinces are mandated to develop such policies under the National Learner Transport Policy. I'd also just like to pause to emphasize here that we did hear testimony yesterday that COSATMA has been using a 2022 or 2020 draft of the national policy currently. Just to state the obvious, that is not the current national policy that is binding and that is actually relevant to whatever province's provision of scholar transport entails. It's still a draft policy, and the Department of Basic Education and the Department of Transport has been very clear that their policy revision process is still ongoing. What that means is the national policy adopted in 2015 is still ultimately the policy that's relevant to scholar transport provisioning today. So when we take a look at the Northwest's provincial learner transport policy, as emphasized previously, it's not something that's publicly available. This automatically hinders any kind of accountability that can flow from trying to hold either COSATMA or the Department of Education accountable to the obligations set out in those policy documents. What the Northwest's policy is supposed to provide, and this is something that's very clear from the national policy, is it's supposed to provide a clear and practical guidance regarding which learners qualify as beneficiaries for scholar transport, what specific processes need to be followed when applying for scholar transport on behalf of qualifying learners, what specific processes need to be followed in processing and deciding on applications received for scholar transport, what specific processes need to be followed in securing scholar transport service providers, what planning and budgetary information and processes need to be followed and complied with by the relevant implementing departments, and how service providers' provision of scholar transport should be monitored. However, what we see is that the Northwest's policy is unfortunately a verbatim replica of the national scholar transport policy, which is completely counterintuitive. The National Scholar Transport Policy is supposed to provide very broad guidance to provinces, who are then required to translate those broad provisions into their own provincial policies to make something that in this particular situation would be workable within the Northwest context. The only changes that we actually see to the Northwest's provincial policy is the substitution of references to provincial departments with references to COSATMA and the Northwest Department of Education, and the substitution of references to national policies or national departments with provincial policies or provincial departments in several provisions in the Northwest policy. The absurdity of this really cannot be emphasized enough, because the National Transport Policy is only ever intended to provide broad and general guidance to departments about what is expected of them in trying to provide for scholar transport. It is incumbent on provincial departments to then provide more detail on what is actually required of their own officials when it comes to scholar transport provisioning. The Northwest Policy is also accompanied by a set of guidelines, and what is quite concerning is, even though the guidelines do provide further elaboration of what actually is supposed to occur within this province when it comes to providing scholar transport, the guidelines also openly contradict the Northwest policies in several significant places. So what we'd like to start with is first just unpacking and assessing the determination of beneficiaries as provided for in both the provincial policy, again just to emphasize this is a replication of the national policy, and how that is contradicted in the Northwest accompanying guidelines. So what the Northwest's policy provides for is the transportation of needy learners from grades R to 12 who are required to walk more than 5 kilometers to their nearest appropriate school. Interestingly enough, considering what was told to the Commission yesterday and the debate that continued into this morning, the policy also indicates in general terms that priority must be given to learners with disabilities, taking into account the nature of their disability. Priority must also be given to learners coming from primary schools. To be honest, irrespective of where learners with special educational needs are accommodated, which I think was much of the substance of the debate we heard this morning, they still need to be transported to whatever school they attend. So the fact that they might be attending special schools, as the Department of Education seemed to suggest, does not eradicate their need for scholar transport. They will still need to be assisted in traveling to and from those schools. And the Northwest's policy also commits the departments to providing them with such transport. However, no explanation in the policy is given regarding how the neediness of learners will be established, or what the prioritization of younger learners or learners with special educational needs actually entails. The guidelines unfortunately provide an even narrower conceptualization of qualifying beneficiaries that is inconsistent with the broad approach adopted in the Northwest policy. First, the guidelines indicate that transport will only be provided to learners coming from farms or residing in deep rural areas, which excludes any learners coming from urban or peri-urban areas. Secondly, the guidelines do not indicate that learners with special educational needs will be prioritized within the province, and merely provide that every attempt shall be made to include learners with special educational needs in the learner transport education scheme. So it does not mandate the provision of transport to learners with special educational needs. Elsewhere in the Northwest policy, it expressly excludes the provision of scholar transport to learners living in areas where public transport is available, so as to avoid a duplication of services and resources. Now, it's not clear if this is something that is going to be read or needs to be read in conjunction with the beneficiary qualifications that are outlined elsewhere in the policy. But regardless, it will result in the exclusion of learners from families who cannot afford the fares of public transport. The theoretical ability of learners to access public transport merely because they reside within an area in which there is a public transport network does not actually translate into their actual ability to make use of that transport. The costs associated with public transport render it inaccessible for many families. And these children are currently entirely neglected under the policy, as admitted by the Department of Education yesterday. Neither the Northwest policy nor the guidelines also provide for any kind of exception from this distance qualification of 5 kilometers. And while it is permissible for provinces to apply a distance-related eligibility criteria, it's also accepted that this criteria must be capable of flexible application. Without a deviation mechanism, neither the Northwest Department of Education nor COSATMA would be permitted to lawfully deviate from this distance qualification, and the rigid application thereof allows departments to rubber stamp their decision to force learners to walk to school. Without a deviation mechanism, neither the policy nor the guidelines make provision for any kinds of considerations regarding the terrain, other dangers, fatigue, and weather conditions that learners may face walking to and from school based on the particular circumstances that they find themselves in. The only deviation that is actually permissible under the guidelines is a deviation from the requirement that learners must be transported to the nearest suitable school. The guidelines state that curriculum choice and school preference should not be used as a criteria for the provision of free transport. However, it allows for principals to motivate for a deviation in exceptional and well-motivated cases. But the guidelines do not provide any further explanation of what would constitute such a case, nor how such requests should be assessed. Without such guidance, it is unlikely that the deviation would be uniformly or even well applied by the relevant departments. Moving on to considering the application and procurement process that's outlined in both the policy and the guidelines for the provision of scholar transport. The Northwest policy fails to provide a clear outline of what the specific process is that needs to be followed when first identifying scholar transport beneficiaries and secondly procuring the necessary scholar transport to allow for those beneficiaries to be provided with scholar transport. The policy merely repeats the national policy's identification of the Northwest Education Department as the responsible provincial education department for identifying which learners qualify, and state that it falls specifically on principals in consultation with school governing bodies to identify which learners qualify for scholar transport. The guidelines do provide a more thorough identification of the specific responsibilities of the Northwest Education Department in identifying qualifying beneficiaries and itemizes specific responsibilities that are allocated to district education officers, area project officers, school principals, and CONSATMA in this regard. However, the guidelines do not provide specific details on what we think are several key issues. Firstly, it doesn't detail what process school principals must follow in identifying learners who are in need of subsidized transport, given that these school principals are the first point of entry into the actual application process. Guidance on this count is of paramount importance. Secondly, no information is provided regarding how the education's area project office is required to decide on whether or not to support a request received by a school for scholar transport, increasing the risk of arbitrary decision making. Similarly, no information is provided regarding how the verification of requests for scholar transport is required from the district education officer. And despite indicating that both the education department and COSATMA are both responsible for designing scholar transport service and accompanying routes, no information is given regarding what processes actually have to be followed by the respective departments and how this intersects with schools' responsibilities to identify relevant pickup points and the overall distance learners will need to be transported to and from school. What's become apparent over the past 2 days is the inability of the provincial policy and the accompanying guidelines to make clear where the respective departments' obligations start and end seems to lead to considerable conflict between the departments, but also seems to lead to a sense of departments assuming that another department will be responsible for a particular function, and then sometimes neglecting their own obligations on that front, both of which are detrimental to the provisioning of scholar transport. Concerningly, no clear funding proposal for scholar transport is to be found in the policy either, and it's merely stated that the scholar transport scheme will be funded through the fiscus from the provincial treasury allocation. The guidelines do indicate that to secure this funding, the Northwest Education Department must submit a resource plan for budgeting to COSATMA annually, who in turn must develop a learner transport system budget, but no information is provided regarding what must be included in either of these documents. Scant detail is also provided regarding the procurement of scholar transport services, and the policy merely states that the procurement of scholar transport services must comply with the relevant procurement legislation, and significantly that only authorized operators with approved vehicles may be contracted for learner transport provision. No mention is made of how it will be discovered that operators are in fact authorized and how their vehicles will be approved for the provision of scholar transport. Given the testimony heard yesterday that COSATMA has allowed some service providers to miss 3 biannual inspections for fear that the service providers will fail the inspection, it makes it very clear that this kind of guidance is of vital importance if we're going to ensure the safety of learners making use of scholar transport. The policy also merely repeats that the contracts that will be issued to contractors will be based on a standardized contract developed by COSATMA. No indication of what this contract must do or must include is provided, despite the fact that the policy was ostensibly drafted by COSATMA. Without a standardized contract or more specific details regarding what ought to be contained in the contract, both the policy and the guidelines fail to provide sufficient clarity regarding the role and remuneration of contractors, which is necessary to avoid fruitless and wasteful expenditure. Without a clear provision for auditing and confirming contractors' remuneration prior to payment, the system remains open to abuse, and instances of overcharging by service providers have previously been an issue in the Northwest, which has been illustrated by the findings of several SIU investigations. In 2018, the SIU started to investigate serious maladministration in connection to the affairs of COSATMA in the province, and found and uncovered several instances of service providers inflating their invoices and unduly benefiting from COSATMA. The SIU investigated irregularities and unlawfulness in the procurement process, and an ultimate lack of departmental oversight in respect of the services rendered by service providers. A total identified loss of 7 million rand due to the inflation of kilometers in the payment of invoices illustrates the lack of adequate guidance, monitoring, and evaluation of the implementation of both the Scholar Transport policy and its guidelines in the Northwest. Critically, neither the policy nor the guidelines outlined any timeframes within which the different stages of Scholar Transport provisioning identified above must occur. The only information regarding timeframes that is provided in the guidelines indicates that once the Northwest Education Department has submitted its request for provisioning to COSATMA, it can expect to wait 6 months before Scholar Transport will be provided. A lack of clear timelines significantly jeopardizes the chances of this policy's successful implementation. The transportation of all qualifying learners for the entire duration of the academic year is highly unlikely if neither the policy nor the guidelines require the identification of qualifying beneficiaries, the submission of relevant budgetary documents, or the contracting of service providers suitably in advance of the beginning of each academic year. The risk that this poses is well identified in the inadequacy of COSATMA's attempts to secure increased funding, and I really wish to emphasize this, the budget adjustment window, and not just the budget itself. As we heard yesterday, COSATMA has been aware of their inability to meet the needs for scholar transport in the province for years, which they largely attributed to a lack of adequate budgetary support. However, they waited until after the start of the 2025 academic year to begin an audit of what is required of it to address the shortfall, which as of the end of April, according to their testimony, is yet to be finalized. Whatever is to be gained from this audit will come too late, firstly, to lobby Provincial Treasury for an increased allocation for the 2025-2026 financial year, and secondly, to provide assistance to the approximately 8,000 learners who, a term into the 2025 academic year, remain in need of transport to and from school. Turning to the provisions regarding the modes of transport that are provided for in the national policy and the guidelines. And this is something that is of incredible concern when it comes to ensuring the safety of learners making use of scholar transport. The Northwest policy requires that vehicles for scholar transport must meet the safety requirements that are outlined in the National Road Traffic Act, and that dedicated vehicles must be easily recognizable in order for law enforcement and other road users to identify that this vehicle is being used for scholar transport. Despite its emphasis on ensuring transport safety in the policy, the guidelines, interestingly and tragically enough, allow for the use of various alternative modes of transport, such as bicycles, tractors with properly fitted trailers, carts and ox wagons to transport learners to and from school. How these alternative modes of transport will be evaluated to ensure their compliance with the safety requirements detailed in the National Road Transport Act is not apparent. Moreover, we firmly believe that these alternative mechanisms of transport will be unlikely to meet most safety and visibility standards. Bicycles, tractors, and carts fitted with trailers quite simply do not possess any real safety mechanisms, such as seat belts, a roof, or metal reinforcement frames, which will be needed to improve the chances of survival for passengers in the event of a collision. And the reliability of these alternative methods will also be heavily impacted by changes in weather during periods of extreme heat or severe cold. If service providers using tractors or animal-drawn carts still transport learners to and from school during rain or thunderstorms, learners will arrive at school wet and with damaged books that they and their family can ill afford to replace. Finally, I would like to briefly address the lack of public oversight and transparency that is made available in both the policy and its guidelines. As alluded to above, the policy framework governing the provision of scholar transport in the Northwest is entirely untransparent. Neither the policy nor its guidelines are publicly available. I'd also just pause to note here that after hearing about the use of a specific hotline for reporting complaints regarding scholar transport provisioning yesterday, we tried to look online to try and find these particular contact details and were unable to do so. The only call center number we were able to find was the general call center for COSATMA. And if you try to follow the link on their website to report an issue about scholar transport, you are automatically redirected to send an email to the department's general email address. So while the policy does require the development of assessment reports on the provision of scholar transport in the Northwest, it does not require that these reports need to be made public. These assessment reports are vital to monitoring the implementation of scholar transport in the province, and without them, the only possible means to really assess the effectiveness of the scholar transport system in the Northwest is through the annual reports of the Education Department and COSATMA, and interventions such as this. However, the annual reports do not contain in-depth information about what would, on the same level as what would appear in these assessment reports. And moreover, the policy itself doesn't contain the scope of the assessment and any impact on policy changes, any impact on policy changes that should flow from shortcomings identified within the reports. Significantly as well, the policy and guidelines provide little to no accountability or oversight for the actual decisions that are made by the Northwest Education Department and COSATMA when it comes to the provisioning of scholar transport. Neither the policy nor guidelines allow for the appeal of or review of any decision not to allow certain learners to receive scholar transport. Without an appeal or review mechanism, decisions taken by school principals and officials within the relevant departments cannot be subject to further scrutiny and cannot be challenged in instances where learners or their parents think that a mistake has been made. It's very clear that there are glaring inadequacies in the Northwest policy and guidelines, which, if one understands properly, can provide a clear explanation for the ongoing scholar transport crisis that this commission is here to investigate today. I'd like to move on to the recommendations and conclusions that we have upon analyzing the policy. And ultimately, what we really wish to emphasize today is that COSATMA's replication of the national transport policy really demonstrates a failure to take the development of an adequate provincial policy seriously, and an indication of a failure to apply their mind to the issue of scholar transport. Without an adequate provincial policy in place, it is almost inevitable that the issues we have heard about over the last 2 days will arise. The inability to ensure the effective implementation of the provincial policy that we see in the Northwest, because it mirrors the national learner transport policy, also provides a particular demonstration of the vagueness of the national department, of the national policy, and how little practical guidance it actually provides provincial departments with. And on one hand, this does mean that we have to have a degree of sympathy for the position departments find themselves in when developing their own provincial policies. They're left with very little to guide them and very little to assist them. Consequently, our recommendations are twofold. First, we would recommend that the Northwest policy and its accompanying guidelines should be revised, importantly in consultation with relevant stakeholders, to address the inadequacies that we have outlined above and ensure that all participants in the scholar transport provisioning process have a clearer understanding of what is required of them. Second, we also recommend that the Minister of Basic Education, in conjunction with the Minister of Transport, should exercise their regulatory powers under Section 61I and 72(1) of the South African Schools Act and the National Land Transport Act, respectively, to develop binding minimum norms and standards for scholar transport to provide provincial education departments and provincial transport departments with better guidance regarding the provisioning of scholar transport. We do recognize that this latter recommendation does fall beyond the ability of COSATMA and the Northwest Education Department. However, we think that the scholar transport crisis in the Northwest is particularly demonstrative of the need for greater guidance which regulations can provide. So when we look at how to improve the Northwest's policy and accompanying guidelines, we ultimately would recommend that they need to be substantially overhauled to ensure that a clearer understanding of what steps need to be taken by whom and when to ensure the implementation of a safe and reliable scholar transport that meets the needs for scholar transport in the province. To this extent, we welcome what appears to be a commitment by COSATMA and the Northwest Education Department to revise its policy, as heard over the last 2 days. We wish to draw their attention in this regard to several other provincial policies which we think may provide helpful guidance regarding what specific provisions could be included in a revised policy to try and address the concerns that we've outlined above. However, we would just wish to emphasize that we don't think these policies themselves get these particular provisions perfect, and we also would urge against a direct replication of the provisions that we're going to point to today. So firstly, when it comes to an inclusive identification and definition of qualifying learners, it's important to note and draw attention to the fact that the Gauteng Scholar Transport Policy, Limpopo Provincial Scholar Transport Policy, and Mpumalanga's Scholar Transport Policy all provide good examples of policies that utilize an inclusive definition of qualifying beneficiaries that aligns with the requirements set out in the national policy. Particularly, the Gauteng policy allows for an exception from the distance requirement to be granted in appropriate circumstances. The KwaZulu-Natal Learner Transport Policy and the Free State Scholar Transport Policy also mandate the inclusion of learners with special education needs in the provision of scholar transport. When it comes to how to improve the identification of qualifying beneficiaries, the Eastern Cape Provincial Learner Policy provides a good understanding of what could be used to try and provide an objective assessment of the neediness of learners to establish whether or not they qualify for scholar transport. There, the policy makes use of the Department of Social Development's means test to establish whether or not a learner can be considered needy for the purposes of qualifying for scholar transport. The KwaZulu-Natal policy also introduces a separate set of factors to consider when identifying whether or not a learner with special educational needs qualifies for scholar transport, taking into account the particularities of the difficulties that they may face. It also mandates the use of a specific set of prioritization criteria in instances where the KwaZulu-Natal Department of Education may need to prioritize certain learners in the provision of scholar transport because of issues like budgetary constraints. When it comes to the application process, the Eastern Cape policy provides a clear indication of what specific information about learners needs to be included when applying for scholar transport and what medium an application needs to actually take on their behalf. The Free State policy and the Northern Cape Learner Transport Policy also provide a reasonably comprehensive outline of the process that must be followed in applying for scholar transport and verifying all applications that have been received. Significantly, and we think this is the most important thing, both the KwaZulu-Natal policy and the Northern Cape policy also provide deadlines for the finalization of the application process. And the KwaZulu-Natal policy also provides for an appeals process in instances where a learner's application has been rejected. Finally, addressing our recommendation for the adoption of national regulations that set minimum standards for scholar transport. Because the Northwest policy is a replica of the national policy, the difficulties faced by the Northwest Education Department and COSATMA in implementing its policy uniquely exemplify the difficulties that would be faced by every other provincial education department and provincial transport department in drafting their own provincial policies, when they are left to rely solely on what we think is the unsatisfactory and vague content of the national policy. Not only does reliance on a vague national policy provide little practical guidance, but it also results in the provision of scholar transport across the country that is significantly affected by provincial inconsistencies in program administration. The promulgation of minimum norms and standards for the provision of scholar transport would provide provinces with better guidance to enable the realization of learners' right to scholar transport and assist in reducing provincial inconsistencies in learners' access to their rights. The promulgation of regulations can also provide a mechanism through which the Department of Basic Education and the Department of Transport can consult with and engage with affected individuals and expert stakeholders during the regulatory process. This allows for an important leveraging of their collective experience to develop minimum norms and standards that address the specific demands and constraints of scholar transport. Binding minimum norms and standards have been used elsewhere in the education sector to bring uniformity to the provision of access to basic education. We've seen binding norms and standards that have been used to address safety measures in public schools, the prohibition of initiation practices, regulating school funding and school fee exemptions, and also regulating the provision of school infrastructure. We contend that at a minimum, these norms and standards should include the following. Firstly, and again, I know I emphasize this a lot, but we think it is fundamentally important, clear time frames within which schools or guardians are required to submit their scholar transport applications, the form that the application should take, and to whom the application should be submitted. Again, clear time frames then for when the corresponding departments should inform learners of whether or not their application has been successful, an appeal mechanism and process that learners who might be aggrieved by a particular decision can follow, provision catering for scholar transport learners with special educational needs, the roles and responsibilities of all key stakeholders, an obligation on provincial departments to adequately plan budgets and the number of learners in need for scholar transports, and provisions relating explicitly to the types of vehicles that may be used for scholar transports and the regularity with which they need to be assessed. Ultimately, we believe that the promulgation of binding minimum norms and standards for scholar transport will assist in ensuring greater accountability in the provision of scholar transport because of their enforceability. Existing policies are not only inadequate, but they also sometimes have limited legal enforceability. Regulations set clear baseline norms and requirements that provincial education departments and provincial transport departments can legally be required to conform to. I think it would be highly unlikely that we would sit in a similar situation like we have yesterday and today and be told by provincial education department and provincial transport department that there is no set of regulations that governs the provision of scholar transport in the same way that we were told that there was no and is no provincial policy that governs the provision of scholar transport. We firmly believe that the promulgation of binding minimum norms and standards for scholar transport will ensure that provinces such as the Northwest will receive the guidance that they need to ensure the creation of and implementation of effective and adequate scholar transport policies. Not only would this assist the Northwest Education Department and CONSATMA meet the need for scholar transport in this province, but it would also assist in ensuring that the approximately 170,000 qualifying learners who are in need of scholar transport around the country and are currently left stranded will finally have a reliable means of travel to and from school. We again thank the Commission for the opportunity to make this submission and hope that it will be something that can be of assistance in your investigative inquiry. But moreover, we would really just like to extend the invitation to anyone from the respective departments in the room that we really hope the analysis provided here today can be of assistance in any kind of policy renewal, policy development, or policy overhaul that we hope your departments will be undertaking in the near future. Thank you so much.
Thank you so much. Is that all? All right, thank you so much. I'm going to now give over to the team. Mr. Nkonde, are you leading this one?
Mayor Tebeng will lead this one. Thank you very much.
Okay, Ms. Tebeng.
Thank you, Commissioner. Thank you. Sorry, I didn't get your surname.
I'm Ms. Rankin.
Ms. Rankin. Thank you, Ms. Rankin.
Matoni.
So with regards to the policy and noting the presentations by COSATMA and the Department of Education, do you believe that the policy itself is problematic in that it does not cover the core issues, or is this, do you believe that it's more of an implementation problem?
Thank you, Commissioner. So the issue with the policy is substantive. The policy is vague. The policy is not readily available. And as my colleague, Ms. Rankin, indicated, there are several pitfalls within the policy where I couldn't even characterize it as a loophole, but rather a chasm of issues that are found within the policy. And because of that, if the substance is not sufficient, you cannot expect implementation to be sufficient. So I think they go hand in hand, but I think the root cause of a lot of the issues is the fact that the relevant departments have not applied their mind, have not engaged with policy or policy reforms to ensure that scholar transport is adequately provided for.
Okay, thank you. And what is your view on this dual role approach between COSATMA and the Department of Education?
I do think that it poses practical difficulties when it comes to the provisioning of scholar transport. Let's be honest about that. But I do think that it is necessary. We can't expect the education department to have the kind of expertise that the transport department has when it comes to ensuring that we have the development of routes for the provision of scholar transport, the contracting of the relevant service providers, ensuring monitoring and oversight on that front, but also ensuring, and that's something that I think came out in yesterday's testimony as well, that the routes service providers follow are adequately maintained. But at the same time, it becomes incredibly difficult if we expect the transport department to have access to the wealth of information about which learners are in need of scholar transport. It's something that would be, I think, quite difficult and quite onerous an obligation on the transport department to be able to, without assistance by the education department, access that kind of information. So even though it's difficult, it is ultimately something I think that is necessary. So we could probably turn around and say it's a necessary evil. But what it does really require to ensure the effective execution of is a very, very clear outline of exactly who is required to do what, and particularly when. We can't sit in a situation where it's left open-ended when the relevant education department, in this instance when the Northwest Education Department, is required to have completed its identification of qualifying beneficiaries, because that's necessary for COSATMA to pick up its responsibilities in terms of devising a route for those learners, in terms of contracting with service providers, and also then subsequently in terms of monitoring. And I think if we have to address the issue of monitoring specifically, and I think this has been quite a bone of contention over the last 2 days, effective monitoring will always have to involve schools, because scholar transport provisioning is service providers taking learners to schools. And those are institutions that the Department of Education has officials in and has direct oversight over. It would be, I think, counterintuitive and a waste of resources to try and instill an official from the Transport Department in each and every school in the province to monitor the provisioning of scholar transport. We really do need to rely on schools to do that. We really do need to rely on the Northwest Department of Education to do that. So I do understand there are difficulties when it comes to sharing responsibilities, but if we have to look at the fact that not only does it make practical sense, but we don't want to duplicate efforts, because that's fundamentally a waste of resources as well. We really need to make it work, and our submission is we need clear guidance to outline roles and responsibilities to do that.
Sorry if I can just tag on to what my colleague is mentioning. Within the collaboration and conflict and friction that has arisen between the Department of Education and the Department of Transport, it's not a unique position just to the Northwest. And I think speaking to more of the issue of national binding minimums, norms, and standards, if there is a national level guidance, national level policy that dictates the roles and responsibilities of each department, clearly it can minimize that friction between the departments. Furthermore, it can prevent this fragmented approach that we've noticed across all of our provinces, where each department each province runs the scholar transport program differently.
Okay, thank you. So in your presentation, you mentioned that where the state is aware of significant issues that may hinder the realization of the right to scholar transport.
I'm sorry, can I interject? Commissioner, I'm getting a note from my team that actually Ms. Motoni was not sworn in.
Was she? Okay.
She was not sworn in.
Was she sworn in?
You,
Oh,
okay. No, we just wanted to correct that in case it was not done. My apologies. Thank you. Yes. Yes, I remember now. Yeah. I'm just, we are communicating so that procedurally we are not found wanting. Thank you. My apologies.
Thank you, Commissioner. In your presentation, you mentioned that where the state is aware of significant issues that may hinder the realization of the right to scholar transport, it is required to take proactive steps to remedy these issues. And based on your observations, do you think that the departments concerned have taken proactive steps to remedy the issues around scholar transportation?
No, is the short answer. And the reason for that is twofold. If you take a look at the table that we provide in our submission, it's in, sorry, let me just double check the bundle specifically. Part B of the second bundle on page 9,296. Is that 1,000? No. No. 1,296. You'll see that we've provided statistics over the last 5 years regarding the learners that have been identified as in need of scholar transport and the learners that have been provided with scholar transport in the policy, and the percentage of learners that have been left without scholar transport that have been left without scholar transport. And if we were to see proactive steps being taken, we wouldn't see such a drastic increase and then the stagnation at such a high percentage rate of learners who have been left without scholar transport. So just on an evidentiary basis, I don't think you can look at the service provisioning we see in the province and say that there is clear evidence of effective proactive steps being taken. If I have to consider the testimony heard over the last 2 days, I also don't think that you're seeing proactive steps being taken for 2 reasons. The budgetary stagnation across the last 2 years that was reported on yesterday is very, very clear evidence of that. When it comes to budgetary constraints, we know obviously that the right to basic education is not subject to budgetary restrictions. But we do understand, obviously, that budget is not open-ended. And what it then means is that it is incumbent on the relevant departments to utilize all available avenues to them to lobby for an increase in funding. If for 2 financial years in a row the budgetary allocation has remained the same, it clearly demonstrates that no attempt or no adequate attempt was made to try and lobby for increased funding. And what we've seen very clearly from jurisprudence when it comes on budgetary constraints and the impact that it has on the realization of the right to basic education is that it's not enough for education departments to merely state, well, we have tried to do A, B, and C. They need to demonstrate that a proper business case has been made out. That's normally the phrasing that we see used in jurisprudence on this front, to try and ensure that increased funding is made available. And if lobbying provincial treasury doesn't work, then the obligation is to try and take it a step further through effective intergovernmental channels to national treasury. I do think it's promising, though, that we are seeing this audit taking place now regarding what is the shortfall and what is needed to make up the shortfall in particular. An audit like that will always be the first step to making out a proper business case. But the fact that it's happening now and targeting the budget adjustment window instead of the actual first primary budget allocation for this financial year is a huge issue, because it's always then going to be that it will never be effective for a significant number of learners for a significant portion of the academic year. And the reason why I think this is particularly important to highlight is if you suddenly started attending school because suddenly funds were available for you to do so in September, you've missed out on months of education. And the right to education is something that needs to be continuously accessible to learners, otherwise you will fall behind. It's difficult to implement catch-up plans. It's difficult to ensure that learners stay motivated when they fall behind with their peers. And I think that's also something that we need to use to try and characterize what are adequate proactive steps. You cannot take steps in a current academic year to fix the problems that have arisen within that academic year. That will never be proactive. Those steps needed to have been taken the year previously.
Thank you. You also mentioned in your presentation that the policy indicates in general terms that that priority must be given to learners with disabilities, taking into account the nature of their disability and learners in primary schools. Regarding learners living with disabilities, do you believe that the departments have been complying with this provision?
Again, short answer is no. The thing is that with regard to the department's compliance is that it's become incredibly difficult for us to monitor, simply by nature of the fact that reports are not made readily available. The public documents are not available to the public unless you go through a prior request. So with regard to learners with disabilities, we heard the testimony this morning where there was a back and forth between what is the provisioning for learners with disabilities or learners that require special assistance. And what was indicative, what struck me the most with that was that there was no concerted effort to ensure that not only were vehicles compliant and compliant with the universal design, which is referenced in the policy, to ensure that all learners are able to access the transport. There was sort of this allusion to an instance where other learners helped one of their classmates onto a bus with that have a wheelchair. And while that's, camaraderie is fantastic between learners, but why is that prior obligation placed on a fellow learner? And why is that obligation further placed on, say, the driver of the bus to ensure that this learner is then placed on the bus? And I think that there needs to be more of a concerted effort to ensure that the modes of transport, A, are compliant with the universal design, and 2, that where needed, learners with special needs or with disabilities are adequately provisioned for in the audit or in the needs assessment that the DBE provides to COSATMA.
Sorry, and if I can also just add on that point, I think that's a very good example of what we mean about how the policy sets up the implementation for failure. Because what does prioritization really mean? That's incredibly vague, incredibly broad. Prioritization is also going to be something that's then left up to subjective decision making, arbitrary decision making, and then if we factor it into a situation where budgetary shortcuts can become something that's of a concern, prioritization often impacts on where funds go in a way that really we have seen facilitates a strong degree of arbitrary decision making unless clear guidance is given regarding what prioritization is actually required.
Now, the MEC, when asked about accommodating learners living with disabilities in these scholar transport, responded by saying that they recommend that learners living with disabilities must be admitted in special schools because they're going to be properly accommodated. So, with that being said, do you think that that is discriminatory in any way to recommend that these learners be admitted in special schools instead of mainstream schools?
I think, firstly, from my understanding as someone in the audience, was that there might have been a conflation of a learner with special needs and a learner with disabilities, where one may not be the other. There may be instances where the two do overlap, but one may not be the other. Secondly, I think that the characterization of a learner with a disability being also a learner with special needs sort of allows for the department to shirk its infrastructure responsibilities. Because if we place learners with disabilities exclusively in special schools, whether that may be to the detriment of their educational output or not, which we may debate later, it also then allows for the department to say there are no learners with disabilities in these schools. Therefore, infrastructure need not be developed, and potentially money may not need to be spent to ensure that schools are accessible. So I think in that sense, it allows the department to shirk its responsibilities and then kick the can down the road with regard to allocating infrastructure development to ordinary schools to ensure access. Then just to circle back onto the issue of that I alluded to, like regarding educational output, where if a learner is disabled but can be admitted into an ordinary public school, then the learner should be admitted into an ordinary public school, because special needs schools are, from my understanding, designed for learners that may have intellectual deficit seems like the wrong word, but I think you understand what I'm alluding to, whereby you may be diminishing a child's educational output, furthermore, their ability to pull themselves out of potentially severe poverty through not allowing them to access the National Senior Certificate curriculum or the CAPS curriculum that is currently in place. So I think the short answer is yes, I do think it's discrimination. And I don't think it passes the law of general application principle as contained in Section 36 of the Constitution for it to be fair discrimination or differentiation for that matter.
Sorry, and if I can also just add on that, I mean, irrespective of where a learner with a disability goes to school or where a learner with a special educational need goes to school, they still need to go to that school. So it's actually just not enough for the MEC to say, well, to try and remedy their exclusion from the scholar transport system, we believe that they should attend specific schools. Because the problem of, well, they still need to be transported to those schools remains.
Okay, now moving to the promulgation of regulations, would you recommend that the chairperson of the inquiry to call on the minister to the inquiry?
Yes, we do. We would be most grateful for that as a recommendation. We have been trying to lobby both the Minister of Basic Education and the Transport Minister for a significant period of time and haven't had any meaningful response from either minister on that particular recommendation. It's something that we have come to not as a random thumbsuck, but rather something we've really seen a clear need for because of our involvement in several provinces, in several provincial scholar transport crises that often link back to the fact that officials don't really know what they're doing because provincial policies are so poorly designed and it's set up for poor implementation. So we really believe in this as a recommendation at the LRC, and we would be most grateful for that as a recommendation.
Thank you. Now moving to the appeal and review mechanisms that are lacking on the policy. Does the policy provide other administrative law rights like fair procedures, reasons, and turnaround times?
No. It doesn't. Just no.
Thank you. That will be all from me, Commissioner.
Thank you, Ms. Tebeng. PM? Oh, which way are we moving? Sidiso?
Thank you, Commissioner. Good morning to you, Ms. Rankin and Motani. So, having heard you alluding to the fact that both departments do not have a clear understanding of their respective obligations and responsibilities regarding provision of scholar transport, who then do you think bears the legal duty to provide scholar transport?
They both do. And I think that's something important to emphasize. This isn't something I think you can shift blame squarely on one department or another. What I would say, though, is that COSATMA was the responsible department for developing the policy and guidelines. So the inadequacies that lie within the policy and guidelines, those design flaws, that's the responsibility there and accountability for that should flow primarily to COSATMA on that front. But at the same time, it's open to the education department through their working relationship with COSATMA to have raised these issues and to have sought policy revisions to try and remedy them.
All right. After sitting in these proceedings and listening to ample of evidence being given by witnesses, and with regards to the HOD of COSATMA indicating yesterday, and obviously making an impression that really scholar transport issues are mainly as a result of budget constraints. And also to an extent that he also indicated that due to such, therefore, the right to access to education should be limited. What is your view on this?
The right to basic education is immediately realizable, therefore not subject to any constraints such as budget. And I think it was a mischaracterization by the HOD to say that the right can be limited in this regard, simply because a department, an HOD, an MEC, or any other official cannot rely on budgetary constraints as a reason not to deliver. We may understand on a practical level that budget plays a massive role in your ability to deliver an output. However, that cannot be used as an excuse. If there's a budgetary issue, the department must take proactive steps to procure additional funding from the fiscus. So no.
All right. Thank you so much.
Sorry, if I can also just quickly add on that. It's also very clear that when you go through periods of fiscal constriction, so what we colloquially call austerity or something like that, which is if we look at what South Africa's budget has kind of committed us to over the past few years, any kind of regressive expenditure or regressive budgetary allocation that might take place higher up in government is always supposed to ensure that the most vulnerable are taken care of in budgetary allocations. And the nature of the right to basic education, set up in such unqualified terms, also when read in conjunction with the rights for the best interests of children to be considered of paramount importance in all matters involving children, makes it very clear that issues pertaining to the realization of the right to education should be prioritized by the broader government. So, as much as I wholeheartedly agree, budgetary constraints can never be an excuse that provincial departments can rely on. We also need to consider that it's got further repercussions for national treasury and provincial treasury for where they decide to allocate funds when they go through periods of fiscal constriction. And I think that we also should try and look at that problem holistically as well. The obligations rest across all different spheres of government and all different levels of government on that front.
What do you think are some of the key obligations of COSATMA and the Department of Education in ensuring learner safety and well-being when using scholar transport?
They need to make sure that all of the vehicles and all of the, well, firstly, let's just start with the vehicles. They need to make sure that the vehicles are safe. They need to make sure that they're roadworthy, and they need to make sure that they have adequate safety infrastructure within them. So it was very alarming to hear yesterday testimony that it's not required for buses that transport learners to have seatbelts, for example. It needs to, there needs to be safety infrastructure within these vehicles. There needs to be regular maintenance of those vehicles, and it needs to be something that is monitored by the departments, and there needs to be regular roadworthy inspections to make sure that the standards are maintained. So it is wholly inappropriate to allow service providers to skip inspections because they may not pass those inspections because they haven't been given the funds that they may need to maintain their vehicles, just as a very, very base level. But then it also goes across to looking at the actual service providers. So you need to make sure that you have service providers who are adequately equipped to transport learners. And it was something that was raised yesterday. It's not just a question of do they have the adequate license to be able to allow them to drive a bus, for example, but we should also be looking at the fact that these are then service providers that come into contact with children, and it should be verified whether or not they, for example, appear on the National Sex Offenders Register or the National Child Protection Register. Those kind of clearance certificates should also be issued because that is also something that's integral to ensuring learner safety when making use of scholar transport. I also think something that needs to be considered is making sure that the requirements that are set in place for verifying whether or not vehicles can or can't be used needs to also be quite age appropriate to the fact that a lot of the time, I mean, learners will always be children, but you're also going to be dealing with very, very young children. So the seating arrangements, the size of a seat, the size of a seatbelt that appears on that also needs to be age appropriate. And I don't think we've ever seen any kind of age appropriate consideration be introduced in any of the regulatory frameworks or any of the policy requirements. But that's fundamentally important if we're going to make sure that small children are kept safe while making use of scholar transport. Those are the kind of things we need to see provided for, but we need to see the uncompromising implementation of as well.
On that aspect of monitoring and inspecting vehicles, do you think that these departments are doing enough?
No.
No. Once again, I mean, testimony from yesterday was, in my experience, well, to me, harrowing to understand that vehicles were not tested or inspected in January due to budgetary constraints, but no proactive steps have been taken from January to end of April, which is today, to ensure that in the interim period, some type of inspection must occur. They say that they have a biannual inspection, but when one doesn't occur, how can it be biannual? Secondly, with regard to testimony heard yesterday, where I think the question was posed where if a principal sees that learners attending their school are getting onto a clearly unroadworthy vehicle, what must they do? And the answer provided was report and then let the vehicle go, if I'm understanding that correctly. That is wholly inappropriate. So not only must understandably, the obligation to report falls on the principal, but to let the vehicle go, an unroadworthy vehicle with children on it, leave the school premises knowingly is wholly inappropriate. It is not enough to say that you reported and that's it. It is wholly inappropriate for any government department to say that if you report, that is where the obligation ends. You reported it, the vehicle must go. It is also wholly inappropriate to say that where a parent notices a vehicle is not roadworthy, is unsafe, has been characterized by this commission as a coffin, to say that a parent must on a daily basis debate, do I send my child to school for the hope of obtaining a better future, at the risk of knowing my child might die today? My child may be severely injured today. I may never see my child again because I'm sending them to school in a coffin. That is wholly inappropriate and wholly harrowing.
Sorry, and also just on the inspections, the failure to conduct inspections in January, if you just take it back logically to that first principle that's present there, the inspections didn't happen because service providers weren't paid. So service providers wouldn't have been able to maintain or improve their vehicles. So they would not have passed the inspection. So the response from the department was to say, well, we're not going to have an inspection because we don't want to have on record that buses have failed an inspection because they haven't been able to be maintained or be able to be kept up. But we're going to allow those buses to then continue to transport learners. There is an acknowledgement there of the fact, if not an acceptance that all of those buses would at least be potentially unroadworthy, an acceptance of the potential that they would have been unroadworthy and that they were allowed to stay on the road. That is what is particularly concerning about that testimony. Because if the department has even a suspicion of the fact that those vehicles could have been unroadworthy, they would have been obligated to remove them from service.
While we're also tackling the issue of inspection and monitoring, there's also been issues regarding bullying and harassment that occur in scholar transport. And one particular Mr. Haidati, in our first sitting of this inquiry, alluded to that fact, to an extent that he indicated that a learner was found sitting on the laps of one of the drivers. How do you think these specific challenges should be addressed?
It's effective monitoring. It is making sure that principals are able to probably observe this, or whoever is responsible for receiving a bus at a school is able to observe this and have clear lines of communication. I know a lot of mention was made about there are these numbers that can be phoned and can be called, but again, just to emphasize, when we yesterday tried to find them, none of those numbers were accessible to us online. So the reporting channels need to be made quite clear. It also needs to be made clearer, obviously, to service providers what conduct is expected of them when it comes to transporting learners. It is unacceptable that a learner was seated on a driver's lap, from a safety perspective, but also just in terms of general interaction and conduct between an adult and a learner. If those instances are occurring, it's also because it's not being made clear what the standards of acceptable conduct are.
Maybe I need to just come in there, not on the driver, but on another learner.
Mike, then the standards of conduct to other learners needs to be made apparent as well. And then I think something that started to come out of the testimony yesterday about having someone in the bus, not just to drive the bus, but also to monitor learners in the bus, that becomes a very effective tool on the road. I do agree that it's difficult to transport many children who, by nature of being children, have energy, are energetic, want to be having fun with their friends on the bus or whatever, but there needs to be someone to monitor that, and you can't expect the driver to do that, because if the driver does that, then they're not paying attention to the road, and then it's going to put all of those children at risk. Yes, apologies for that misunderstanding.
Thank you,
Sorry.
Commissioner, for that clarification. Yes.
Sorry.
Ms. Matano.
Just to that point that Ms. Rankin made now with another person being on the bus, the policy actually specifically excludes teachers being transported. And this is also problematic. Furthermore, the issue of having a learner under 13, 2 learners per seat, that issue that was canvassed yesterday, also exacerbates this problem. Because if you have 2 learners that are energetic, that want to play, that are excited about going to school or excited about going home on a bus, that are sitting on top of each other, it is inevitable that a scuffle may occur, bullying may occur. I mean, it's simple logic. Furthermore, if a learner is in a bus with a seatbelt, where the learner is strapped into the seat, and that is made clear to each learner, and that there is not an inspection but a check done to ensure that each learner's seatbelt is on, that stops learners from being able to move around in a bus, that stops learners from sitting on each other's laps, and it limits the ability of learners to taunt each other. Because if I'm sitting in a car with my seatbelt on, I can't turn around, throw something behind me, or whatever the case may be. So I think that the issue of bullying and harassment needs to be considered very seriously. But it also needs to be understood that if you are going to put two people on top of each other, no matter how old they are, and you leave them like that for 30, 40 minutes while they are on their way home, they're going to disagree. So there needs to be adequate safety provisioning in the bus at all times.
You have also reiterated in your evidence that the right to basic education is an immediate right, and it is meaningless if children do not have transport to go to school. Notwithstanding those views, lots of evidence has been brought before us which indicates huge challenges. How do you believe this may be impactful, not only on these children's rights to education, but their right to equality, their right to dignity, their mental health and well-being, as well as their hope for a better future?
Well, I think I'll make it very clear from the start that we do think the failure to ensure that scholar transport is provided to all learners who are in need of scholar transport is a violation of their right to basic education. And that does have significant knock-on effects on the right to dignity, on the right to equality, because there's a clear then differentiation and impact between peers who rely on scholar transport because their families cannot afford to provide them with scholar transport, and learners who find themselves in fortunate enough positions where their families can provide them with transport to and from school. And it's been reiterated again, time and time, by our courts that the right to education is supposed to be a great equalizer within our country. And if we are unable to ensure that the mechanisms of access to education are actually equal in application, then the equalizing effect of education will never come to bear. And if you look in the Northwest's context specifically, it's not just a question of, oh, learners are sometimes being transported by using Scholar Transport, and there are learners who are in need of Scholar Transport who are not being provided for. If you look at the actual policy, the actual guidelines, which is something we emphasize in the submission, the qualification of beneficiary there is in and of itself discriminatory because of the discrimination it poses between learners coming from urban areas that are connected to public transport networks and learners coming from farm or deep rural areas, which the policy exclusively caters for. So I do think there are profound limitations on the right to education. I think there are also profound limitations as a necessary consequence thereof on the right to equality and the right to human dignity as well, because you're telling learners that their recognizable need to be transported in safe and reliable conditions to and from school every day is not something that is being prioritized.
All right. I'm sure you've heard yesterday while we were sitting in this inquiry that one of the testimony from one of the witnesses was that there was a certain parent who had a very gruesome feeling regarding their child using a Scholar Transport that looked like a coffin, to an extent that she indicated that it was very painful to even think of a child not coming back from school. What do you think is the importance of having a child and a parent role in decision making when it comes to Scholar Transport?
It's very important. It is very, very important. And that's why the fact that you see such a lack of transparency regarding the policy framework that regulates the provision of Scholar Transport in the Northwest, the fact that you see such a lack of transparency regarding reports generated on the provisioning of Scholar Transport in the Northwest is particularly concerning, because parents and learners need to be involved in these processes. And if they don't have access to the basic information about what they can demand from a school when it comes to ensuring the safe transport of their children, for example, parents will never really be able to involve themselves in any meaningful way within that discussion. They'll be able to try and cry out about the desperation and the situation and the circumstances they find themselves in. But their ability to extract accountability is limited because they don't know what standards to hold the department to. So completely agree they need to be involved. First step there is ensuring greater transparency regarding the regulatory framework. Second thing, and this is why our recommendation is specifically tailored to this, any revisions to the policy need to invite the participation of all interested and affected parties, like learners, like parents, but also teachers, school principals, school governing bodies, service providers themselves, for example, to make sure that the frameworks that we would hopefully see developed in the future can provide affected and impacted parties with the ability to have their voices heard. I mean, that's also just a basic principle of any kind of administrative process that needs to be followed in developing any kind of regulatory framework.
In a submission yesterday, the HOD of COSATMA made it very apparent that a blame should be put on service providers for inter alia fraud, negligence, mismanagement, and to the most extent, the challenges as highlighted. Pertaining to these Scholar Transport challenges, according to your perspective, who should entirely carry the blame?
So while there may be issues with service providers, it is not appropriate to squarely place the blame on them. Because as COSATMA, you have contracted them. So are you not liable or responsible for the contracts that you are overseeing? While there may be issues of certain service providers inflating kilometers or using unroadworthy vehicles, it does not mean that because they have done that, that it immediately excludes you from all blame. As a government department, you must conduct due diligence on any contract that comes across your table. So COSATMA is still liable.
You've also indicated, and I'm asking about the policy, that it is not made available online. Do you think there's a deliberate motive behind this?
I think that might be that does call for, I think, speculation on our part, which I don't think would be responsible for us to answer to. But what I will say is, regardless of the motive, it is negligent to not make available the policy framework that regulates your department's conduct. So best case scenario, happy to concede that I do think it is negligent at the very least.
All right. Now let's talk about learners living with disability. You mentioned that it's very important that the departments ensure that scholar transport is afforded to these learners. And you made it very critical. And in your submission, it was clear that they are not being prioritized. So my question is, should scholar transport services prioritize the needs of learners living with disability over the needs of others?
So if we look at the national policy, it does make clear that prioritization does need to be given to learners living with disabilities. So on a policy framework level, that prioritization already does exist. So that is ultimately what we should see provincial departments taking on board, because it's the standard that's been set by national government. And it also makes sense when you look at the heightened obligations of reasonable accommodation that rest on any service provider when it comes to learners with disabilities and special needs.
Right. Can scholar transport services be held accountable for perpetuating systematic inequalities such as racial and socioeconomic segregation?
Sorry, just to clarify, do you mean the providers or the departments?
The departments.
Yes. They are obligated to make sure that they design and implement a system that addresses inequalities. Like we said previously, the right to education is supposed to be an equalizing right. And if you look at what providing scholar transport in and of itself does, the underlying purpose and rationale there is to provide access and overcome geographical and socioeconomic barriers that would otherwise prevent learners from being able to access education. So when COSATMA and when the Northwest Education Department fails to ensure the effective implementation of a scholar transport system, they are responsible for entrenching socioeconomic disparity, and also to a large degree then, and it's very closely linked obviously in a South African context, racial inequality, and then also compounded by geographical exclusion within rural and urban areas.
All right. You've also reiterated multiple times in your submission that the Northwest Department of Education as well as COSATMA do not have their own policy that they have adopted, correct? Right.
Yes.
Do you think this could be characterized by probably ignorance, laziness, or lack of having regard to this very important conversation?
I think that it can't be characterized as ignorance, because if you look at the national policy, it's very clear from the terms thereof that it is envisioned and required of provinces to develop their own policies. So just a very basic reading of the national policy makes it very clear that that obligation does exist. I do not think that you can turn around and say it is difficult to understand that. And the reason as well why I would say ignorance is not an excuse here, nor is it ever really, is because there was an attempt to try and create a provincial policy. That attempt just was a copy and paste job. So there's a clear recognition of there is a need for a provincial policy, and then there was potentially laziness, potentially negligence, potentially a failure to apply one's mind. Again, we can't really speculate on the motive, but the motive is irrelevant because the obligation rests on any government official to make sure that they diligently pursue their constitutional obligations, right? That stems not just from Section 7.2 of the Constitution, the obligation that would rest on both COSATMA and the Northwest Education Department to ensure that it takes steps to respect, protect, and fulfill the rights, like the right to basic education contained in the Bill of Rights, but it also stems from provisions regarding and regulating the public administration in Section 195, which all clearly require that there needs to be due diligence, there needs to be concerted effort on the part of all government officials to discharge their constitutional obligations. So honestly, I think the motive is irrelevant. I think what we can see on paper and what we can see in reality is that those obligations just were not met.
Okay, Ms. Wenken and Motani, after having this impactful conversation, do you believe that the right to access to education has been violated?
Yes.
Who has violated the right to access to education?
Jointly, the Provincial Department of Basic Education and COSATMA.
That'll be all from me, Commissioner. Thank you so much.
Thank you so much, Mr. Lekoma. PM, PM. Your recommendations, other than the ones that you had already submitted, you'll still give us more in writing.
Oh, there, sorry, I've got it. So our recommendations, I think, are fully canvassed in the submission. The recommendations are twofold relating to improvements to the Northwest provincial policy. But what we did say is we were under the impression that that would have already been provided to you because we did think that that was quite a basic document that both departments would have had access to. So we'll still provide that to you. We have a copy of it that we were able to ascertain. But I think when the submission is read in conjunction with that policy, the substance of the recommendations that we make at pages, sorry, let me just get the pages here from the bundle. The recommendations that we make at pages 1,316 to 1,319 regarding the specific policy, when read with the analysis provided at pages 1,297 to 1,300 and there were a lot of things to analyze. 1,315, those recommendations are fully substantiated to the extent that it would also maybe be of assistance because we do make reference to other provincial policies in those particular recommendations. I'll also endeavour to share those policies with the Commission as well. And then our recommendations regarding the adoption of minimum norms and standards that are canvassed at pages 1,320 to 1,323 also canvass our basic reasoning for support thereof. However, if the Commission would be of the belief that further information regarded there about why we actually think not just is it advisable to adopt minimum norms and standards, but in fact there is a mandatory obligation on the Minister of Education and the Minister of Transport, we are more than happy to supplement the submission with further information on that front, because we do think that it's not just desirable in this particular instance to set minimum norms and standards. We think if we consider the nature of the regulatory powers and the nature of the impact of the ongoing scholar transport crisis, it becomes apparent that it is in fact a mandatory obligation that rests on both respective ministers to adopt such regulations. So we're more than happy to further substantiate the submission on that front, if the Commission thinks that would be of assistance.
Yes, so where I was coming from is because there were certain questions that were posed to you, which you might not have canvassed fully in the recommendation. And that is why I was asking if you would be able to also submit further recommendations in writing.
I think we'd be more than happy to provide a further submission, particularly on the evidence, I think, that has, in the testimony we've heard over the last 2 days, and how that impacts with the assessment that we've made, not just of the policy, but also further recommendations regarding implementation. So we would be more than happy to provide the Commission with that as well.
Yes. What do you think is the challenge when you have a department that deals with scholars vis-a-vis a department that deals with transport, wherein you then also say they've got a joint responsibility to ensure that scholar transport runs effectively and efficiently?
I think there are two difficulties. I think one, like I've already discussed, there is the inevitable difficulty that accompanies collaboration between different departments. But again, to emphasize, we think that clearer guidance regarding specific responsibilities will assist with that. But we also think that it's important to understand that this takes place in the context of a cooperative governance structure. So departments are meant to be working alongside one another when there are joint responsibilities. But the other thing is that when we look specifically at potential shortcomings that may exist when it comes to COSATMA that might influence their execution of their responsibilities, specifically contracting with service providers, specifically the monitoring and oversight that happens there. The Department of Basic Education, the Northwest Education Department, all other provincial education departments have, one would hope, a stronger understanding of what working with children requires and what their child-specific obligations are. So it's why you would probably see, one would hope, although we know that it has been something that's been controversial in the past, been subject to litigation and in certain provinces, an understanding that in devising a policy and in implementing that policy, provision needs to be made in an age-appropriate manner for children, because the education department officials are always working with children and always working with educators. We could understand potentially that the ingrained knowledge of what child-appropriate measures are required and entail might be something that COSATMA and other provincial departments of transport may lack, and that may potentially explain, and important to emphasize, not justify, the testimony we heard yesterday regarding the fact that COSATMA was willing to transport learners in buses that didn't have seat belts and to put more than one child in a particular seat, for example. There may be knowledge gaps that might exist within a department that's not ordinarily accustomed to working with children, and the specificalities that accompany that. But again, because this is a collaborative exercise, it should be incumbent then on the Northwest Education Department to, when they are in collaboration with COSATMA, looking at what is being provided to learners, draw to COSATMA's attention that this is actually something that falls short of what is an age-appropriate and child-appropriate service provision. If not just in terms of regular monitoring and oversight, maybe it's something, and it actually should be something, that should happen proactively to try and provide the necessary training, the necessary information to the relevant officials within COSATMA and other provincial transport departments that are tasked with dealing with scholar transport specifically. I think those are the kind of steps that we need to see implemented in order to fix the issues that you identify.
So you envisage a situation where the traffic officers themselves should be trained in how to deal with children? Or are we looking at a situation where we augment, from the department side of education, rather, bringing their officials that are already trained in that field to rather deal with children?
I think that it would I think both could be effective, but I think what we would see to be something that could be the most effective within a context of constrained resources and needing to make work what is available to us. Because as much as we turn around and say that there needs to be increased budgetary allocation, we also can't rely on that to justify duplication of efforts and wasteful expenditure within service provision. I think that better training of officials within COSATMA, the better flow of information to those particular members of the department that are tasked with overseeing scholar transport, because it does not appear to be the entire department that is tasked with that particular area of service provision. Making sure that they receive adequate training and adequate guidance would prove to be the most cost-effective way of trying to deal with the problem, because you then don't have to take officials and move them around between departments and increase the workload of specific officials. I think the education department's officials will probably also find themselves under immense strain if they're now also having to work within the transport department's functionary areas. And then you'd maybe also potentially see a duplication of the same issue, where they don't have the necessary transport expertise to be able to make the best use of like what roads to use, how to maximize on route developments and those kind of efficiency considerations.
And with regard to just ensuring the safety of the learners in the transport itself, I did not really hear you there. What do you envisage should be happening from the Department of Education side, so that we don't have a situation where learners are sharing a seat, or learners, there's one learner on top of the other, or there's bullying and so forth?
So, firstly, I would like to just emphasize that the policies envisage a collaboration between the two departments. So it cannot be said that, ensuring learner safety falls squarely on COSATMA or falls squarely on the DBE. It is both. Both of them are responsible. So I think, firstly, this I will re-emphasize simply because I find it very important to have a vehicle that is roadworthy, a vehicle that is appropriate for the transportation of learners. I think it is deplorable to suggest that an ox wagon should transport learners to school. So firstly, that obligation does not rest on either or. It rests on both. So where a principal, a parent, a teacher, an official sees a vehicle that is not roadworthy to the eye, because some things that determine whether or not a vehicle is roadworthy cannot be seen with the eye and must be inspected. You cannot see on the road whether a car has a rusted chassis. Where they see a vehicle is unroadworthy, to simply stop at reporting. I think that it is completely justified for a parent or a principal or a teacher to stop a vehicle from leaving the school premises if the official has a genuine fear for a learner's safety. Secondly, with regard to the safety within the vehicle regarding bullying, harassment, etc., I think there also needs to be an education on learners. Learners need to be taught. You don't all of a sudden know one day that you need to wear a seatbelt. There needs to be a concerted effort that may include other government departments to ensure that learners are road safe. Look both ways before you cross the street. Make sure you have your seatbelt on. Things like that. Also, it falls not either or, COSATMA or the DBE, to ensure that learners are safe in the vehicle, not only from an external collision perspective, but also from safe from bullying, safe from harassment, safe from unsafe environments within the vehicle.
All right, thank you. Thank you for that. So you've referred to a number of policies, which some you say, there's lessons that can be taken from them. Will you also, in your then submissions, your further submissions, just please also attach those policies for our information. But thank you so much for your insights into this matter, and you are both excused.
Thank you, Chairperson. We will do so.
Thank you so much. If I can just quickly ask then, I know that there was mention of, I think, the 16th of May for the further information that was requested from COSATMA and also from the Northwest Education Department. Similarly, would you like the further information from us by then?
Yes, please,
Sure.
if you can just also use that deadline.
Of course.
Thank you.